Hey there, welcome back to yet another episode in the journey of demystifying the Patent Act. In the last episode, we witnessed the to and fro between the applicant and the controller as the application was getting examined. We are waiting for the controller to issue its decision or pass an order as per section 15. At this stage, we can't wait to get a grant on our hand. As we wait for the grant to arrive, in this video, we will go over the granting process, the patent rights, and associated terms and conditions. So let's get started. So as per section 43, a patent will be granted if the application has not been refused by the controller under section 15 or the application is not in contravention of any provision. Now, what contravention are we talking about? One such example could be the secrecy provision. If the applicant has not followed or respected the secrecy provisions, or if the application was filed in a foreign country before filing or before disclosing the same to the patent office in India, then an application can be refused. As the patent gets granted, you will have a date of patent, which is nothing but the date of filing. Also, the patent will be in a prescribed format. It will have effect throughout India, considering all the states and all the union territories. And ideally, it will be only for one invention, as per section 7.1, 10.5. However, if there were multiple inventions in a patent, then that will not be a ground for objecting the validity of invention. Interesting nugget. Now, what happens if an applicant dies before the grant of the patent or a company ceased to exist after the grant of the patent? A substitution can be made to replace the applicant in such scenarios. Now we have the patent rights with us. Time to enforce them. Great power comes with great responsibility. Patent rights comes with terms and conditions. Let's go over the terms and conditions one by one. Section 47 lists down the terms and conditions that you need to keep in mind while you enjoy your patent rights. So the government is free to make or import products which are protected by your patent for its own use, or use the process which is protected by your patent. Similarly, in case of medicine and drugs which are protected by your patent, government is free to import for its own use or for distribution to dispensaries, hospitals, and medical institutes. Another such use case is when others use your invention only for research and experiment purpose or for imparting instructions to students. Such scenarios will not be considered infringing your patent rights. You cannot sue them. Now, since you know the terms and conditions associated with the rights, let's see what rights do you have. Section 48 talks about rights of patentees. As per section 48, a patentee has an exclusive right to prevent others from making, using, offering for sale, and selling the patented product or product made out of patented process. Similarly, importing of the product for these purposes also is not allowed. There could be multiple applicants for an application. Therefore, there could be multiple patentees for a patent as well, isn't it? In such cases, each patentee has an equal and undivided right in the patent. Now we have some clarity about the rights that we have. But before we enjoy the rights, let's go over another use case defined by the Act, which says that it will not be an infringement activity if your invention is used in vessel, aircraft, or land vehicle, which is registered in a foreign country or belongs to a foreign resident and is in Indian territory temporarily or by accident. Now, in such cases, the use of your invention will not be considered as an infringement. Let's learn a few more details about it. So, as per section 49.1, use of invention in them is not considered as infringement, provided use was on board the vessel for its actual needs only, or use for the purpose of construction or working of aircraft or land vehicle. However, this section is not applicable to all the foreign residents. In particularly, this is not applicable to those foreign residents who belong to a country which does not provide similar rights to Indian residents. So give and take, the reciprocity of the rights. With this, we have further clarification on the rights and who all we can go behind. So for how long can I enjoy the rights? Term of patent. Section 53 talks about the term of patent. Normally 20 years from the filing date, but then let's go over the specific cases. For ordinary application, the term of the patent will be 20 years from the filing date. For convention application, filing date in India is considered to compute the 20 years. For PCT national phase, interestingly, the international filing date is considered to compute the 20 years. For divisional application, filing date of the original application. So this brings us to the end of this session. We have our grant, we have our rights, and we also got to know about the terms and conditions associated with the rights. In the next episode, we will spend some time on understanding the rights of the co-owners and any dispute resolution mechanism that is available to them for resolving their dispute with regards to the patent rights. So I'll see you in the next video. Till then, be good and take care.